This is the Fifth Estate Winning Headlines, your media police post. In this segment, we summarize some of the headlines that you might have missed this morning. We also take a look at the political pieces that we call cartoons in this country. Today is the 2nd of December 2020 and I am Miss Gay.
I'm JM.
And I am GK. In case you missed the headlines, here they are. In the Daily Nation, murder threats in COVID billions theft plot. In the Standard, ROTICH, I was fixed. And in the Star, DP Ruto's BBI game plan as he meets 150 MPs and other stories. Let us begin with the Standard.
As usual.
What is the former CS of Treasury saying?
Former CS of Treasury is alleging that he was a sacrificial lamb in the whole Kimwere and Aror saga. He says that on 23rd of July 2019, his world turned upside down when he was charged with graft as a consequence of the Kimwere and Aror corruption saga. In the court papers he filed before the court seeking to quash this case, he said that he was isolated for the hang. He says he's jobless and no one wants to give him even an ear for a consultancy. He also says that should he want to get a certificate of good conduct, it now says that he has a criminal case pending against him and that no one is calling him. He then says that despite his then colleague Judy Wakungu, Environment CS, requesting the Treasury to borrow funds to finance the two projects, Kimwere and Aror, and the Kerio Valley Development Agency directors approving them, they all went scot-free and he was left all alone to hang. He also accuses the state of hounding him for merely undertaking a statutory duty where he was requested by a cabinet colleague, and then he finally said that it was his duty. He was bound by law to sign all financing agreements on behalf of the government, yet he was not aware of the procurement process to get the contractor, nor was he involved in the identification and the sourcing of the finances. In short, he's saying, somebody save me.
Save me.
No, ignorance is no defense. First of all, he was not aware of the procurement process, and he's a cabinet secretary in charge of the treasury, in charge of monies for government. And secondly, these are the occupational hazards of becoming a minister.
Yes.
And most of all, of minister for finance.
Yeah. They say that the first casualty of war is truth. So I have holes in what he said. There must be some holes there. But also that finding a sacrificial lamb on whom to tag the blame for is the first toolkit that politicians get. So someone had to take the fall, and
in this case, it was him.
In this case, it was him. So tough love. We have a 3-part criteria that we are going to use to break down the headlines. We will ask ourselves, is it topical or speculative? Is it repetitive or groundbreaking? Is it thoughtful or just plain lazy? I thought it was quite poetic. It is not even part of it. Very topical. A little bit speculative, but let's park it for now. Let's move, please, to the Star, DP Ruto.
Yes, so DP Ruto's BBI game plan. The Deputy President, the Star, says has fashioned a strategy to either completely scuttle the referendum or neutralize its political consequences. He seems to be in a catch-22 situation. And the big question for him is, what signal will this send if he, as a hustler, if he joins the dynasties, quote unquote, is what the Star is asking. And that's why he's feeling a bit of discomfort. Yeah. And finally, the Star also does tell us about the latest petition that has been filed by the governor, this is Kivuda Kibwana, and he's seeking the court's interpretation on two things. A, if state officers can use public resources to promote a popular initiative, constitutional amendment, and B, if the referendum should be a single issue one or an omnibus legislation bill.
For me personally, DP Ruto is perhaps doing the best thing for him. Hear me out. He's striving to maximize his payoffs. He's trying to make a decision, or at least occupy a decision that will not make him worse off in 2022. And he's really trying to weigh out what this might be, right? Yeah. And you have his primary thrust has been to pander to the base, which is the masses. And if perhaps they're saying, no to BBI, he's wondering, do I lose them and try and make some elite contract with these other guys? Or, so there's a payoff there that he's trying to gauge. I don't blame him for occupying a middle ground consensus.
Yeah.
But I would also like to remind his hustler followers that he's always been dynasty. If you think back to the elections, he was either with one or the other.
One or the other.
So
this is
if
true.
he's with both, it's all the same to me.
This is true.
Absolutely.
So, Our last headline is the Daily Nation, and this is murder threats and COVID billions theft plot.
Yep.
And this is basically a procurement manager at Kemsa who is now confessing that shadowy officials, known as the deep state, were making his boss, former CEO of Kemsa, John Amanjari, sign all these contracts. And basically what he's saying is that these shadowy officials, or the deep state, got tenders worth 2.1 billion shillings. And he's saying, Mr. Kajwang and the Senate were basically asking him, why didn't he speak up before? Why did he wait till, there was some mischief? And he said that things started falling apart at Kemsa when commitment letters and things had moved to the CEO's office and away from the procurement office. So away from the proper way to do procurement in government.
I think he can join. I think he can join ROTICH in the "I was fixed."
Absolutely.
I was fixed, but I mean, I think this speaks to whistleblowers and how it is to be in this country to whistleblow. Your life is always under threat and things like that. But for this, I will say that the wheels of justice are turning. Uhuru Kenyatta said that these people should be found and dealt with, and this is part of the process.
Yeah, and people should put their foot down. CEOs, ministers, put their foot down on some of these contracts. Some of the pressure coming from the political circles. Yeah. Because sometimes even those deep state characters are just political posturing. It's just a game of bluff.
Yeah.
It's a game of chicken. Yeah. If you move,
exactly,
they win.
Yeah.
Absolutely.
So who do we give our winning headline? I particularly like the Standard. ROTICH, I was fixed.
Although he was not.
It sounded nice. I would buy this paper.
I would buy it too.
There we go. There you have it. Standard gives us our winning headline. Onto the political pieces that we call cartoons in this country, where we also have a 3-part criteria. We ask ourselves, is it humorous or dry? Is it satirical or pessimistic? And is it effective or just plain lazy? Shall we begin with a Standard?
We have a caricature of former, can I call him former? Sitting duck, yes. US President, Donald Trump. And he's, I think, the Pied Piper in this instant.
Yeah.
Playing a tune towards the White House, and he's being followed by rats of hate, racism, xenophobia, misogyny, Islamophobia, and sexism.
That was 2016.
That's in 2016 when he got into the White House, and now in 2020, as he leaves the White House, he's being followed by his very faithful rats of hate, racism, xenophobia, misogyny, Islamophobia, and sexism.
I see.
Yeah, okay.
The implication here being that all of those ills were bound to him and will go to hell with him.
Wow.
Yeah.
All right. Don't know if I agree. But Daily Nation, we are still in America. And finally, so we have a caricature of Uhuru Kenyatta, and he's holding a phone, bent over and sort of turning around. And on the other side, you have Trump handing over the phone to Biden, and he's saying, President-elect, you have a call from Obama's home country. So I think Uhuru was one of the last few people to sort of be saying congratulations. I think a lot of people had said congratulations much earlier. Maybe Uhuru waited till it was diplomatically safe to do so. But yeah, kudos to them for making the congratulations. Can we toss those? They're so,
yeah, definitely.
Sorry, they did not inspire me at all.
God.
Let's have a look at the star.
Yeah.
Here we have a caricature of President Uhuru Kenyatta on the guitar, Raila Odinga on the microphone, and Atwoli on the keyboard. And you've got as well William Ruto shaking the shakers.
And is that his leg that's up there?
He's really
it's
enjoying
his leg,
this
absolutely.
tune.
And he's changing his tune here, it would appear, and he's saying nobody can stop reggae, is what that half of the band are saying. And you've got the opposing band who are saying yes we can, led by Martha Karua. This is Boniface Mwangi Ndi and
the band of nihilists.
The band of nihilists. Absolutely. Quite a comical one.
Yeah, I like it.
I like it. I think we should give this our winning cartoon.
There you have it. The star gives us our winning cartoon. And now for our final thought, but before we get there, please remember to subscribe to our YouTube channel.
Today's final thought, or rather this week, we are in Criminal Class 101, as said by 2J. And today we will be looking at criminal law. Criminal law is a system of laws concerned with the punishment of individuals who commit crimes. And I'd like to make a distinction here between criminal law and civil law. Civil law, let me begin there, is between two individuals. It's private, it's a private matter, and tort, what we looked at on Monday, is part of that law. If, for instance, JM wrongs me, then I can take this wrong to a civil court. However, criminal law involves the government deciding whether or not to punish an individual for either an act or an omission called a crime. What is a crime? A crime is an unlawful act or omission which is an offense against the state. Because if I was to talk philosophically, I think, the state has the responsibility of protecting all of us as citizens. And sometimes when you perform an act, the state takes on your responsibility in ensuring that that crime is punished by suing the individual. That is why in a civil case, JM versus myself or myself versus JM, we will use our own names in that case. But in a criminal case, the state will sue on our behalf. That is why it will be Republic versus Wanyonyi or R versus Wanyonyi. And that is how criminal cases are stated. There is a maxim in criminal law, and I will bear with me if my Latin is not that good. Actus non facit ream nisi mens sit rea. Difficult words. But what they mean is that the doing of an act does not make a man guilty unless he has a guilty mind. And this goes into the essential elements of what makes up a crime. So a crime, and I will stick to only two elements of what makes up a crime that are in that maxim I've stated, must have two things. The act itself, so you must perform the criminal act itself, and this act is usually defined in law. Then the second thing is that you have to have wanted to do it. You have had to have had the intention to commit the crime. So those two things are called actus reus, that's the act itself in Latin, and mens rea, that is the intention to have committed the act. I'll give an example. In the case of a murder, I will, God forbid, kill someone. That is the act itself. However, what precipitated that act? Had I premeditated it? Did I have what we call in Kenyan law malice aforethought? Had I thought about doing this act, going to this person, thinking about how I will commit the crime, and knowing full well that the consequence of my act will be their death? Then I have committed a crime and I will be charged for it. Now, the element of actus reus is very easy to prove. We can definitely prove that you performed an act and this act led to the death of a person. But the element of mens rea, the intention to commit a crime, is quite difficult to prove. And in fact, you cannot be charged if you committed the act involuntarily. And involuntary acts are broad, and the defenses for crimes can be quite tricky. And I think that GK will speak to one of the defenses in her segment. But proving it, you cannot be charged if it was involuntary. For instance, if you were having an epileptic fit and then you were driving a car and that car had an accident and that led to the death of a person, that act of being in an epileptic fit was involuntary. Therefore, even though a crime happened, someone died, you cannot be charged for it. Another contentious defense is insanity. You cannot be charged for a crime if you had no understanding that at the time you were doing the act, you were performing a crime. Sometimes you can push it and say that mass intoxication, like you are ridiculously high, either through alcohol or drugs, can lead to a situation of temporary insanity. However, this is extremely difficult to prove. In short, I'd like to tell you something and end with this. Deciding what is or isn't a crime is a situation of simply a matter of the country in which you are in and the time in which the place is. And I will use a contentious thing to prove this. Sometimes you can have something that is both immoral and illegal, because originally crimes were thought to be acts that were immoral. But again, you can have something that is illegal, but not, that is legal and immoral, and something that is illegal and not. Have I said that correctly? Let me go back again. You can have something that is immoral and illegal, something that is moral and legal, something that is immoral but legal. And the definition of what constitutes a crime is contentious, because it is based on the circumstances of a state and a society. I end there.
Thanks for that.
Great. And let me speak a little bit about the adversarial justice system versus the inquisitorial justice system. And these are two different modes of prosecuting a case. One, we practice it in the common law systems, and then the other in the civil law tradition. And so our criminal justice system is an adversarial one, borrows from that of Britain, and we compare that against the inquisitorial method that borrows from the civil tradition. And so the adversarial one pits the prosecution against the defense, with a judge sitting somewhere and listening to how both the cases are being argued out, or how the lawyers are arguing out that case. And that system assumes that the best way to get to the truth of a matter is through that competitive process between the prosecution and the defense to determine the facts and to apply the law accurately. And then you've got the inquisitorial system, where the presiding judge is primarily responsible for supervising the gathering of the evidence necessary to resolve that case. So he actually is, pretty much a prosecutor, and he's the one who leads the questioning, the interrogation of witnesses, of the accused and the accuser, and what have you. He leads that inquiry. Let me speak about three main demerits of our system, the adversarial method, and perhaps suggest why we should consider adopting a more inquisitorial approach. So first, and this is really on the part of the person who's accused, the victim has to relive the events of the day when he or she was, the crime was committed against him all over again. And because that process demands that the victim relive that experience on the witness stand, there's cross-examination which goes on. And can you imagine, for example, having to recount the day that you were robbed violently, or the day that you were raped, or that kind of thing? Not very pretty, and it's actually quite a painful experience. Yeah. And in the inquisitorial system, the prosecution, the judge, would mainly rely on the statement that you have written, and would not probe, so much beyond that. But number two, prosecutors of the case in the adversarial system, such as in our country, the DPP or the DCI, have a personal incentive to win convictions for political gain. So sometimes there's a bit of political gain and political incentive that comes into the office of the prosecutor. We've seen that recently in our two prosecutorial agencies. And sometimes that can influence a case in a particular direction. And number three, the method of the adversarial system is skewed, I think, a little bit more towards suppression of evidence rather than really uncovering the truth objectively. And here we see how certain clients will obtain the services of very high-profile lawyers, some of whom even intimidate judges just because of how they look, how they dress, how they talk, and what have you. So sometimes you can get a great orator for a judge, who ends up, suppressing evidence, using tricks, using all sorts of methods, and that really does not uncover the truth, particularly for somebody who has been accused of a crime. So that's the long and short of our adversarial system. Interesting.
So I looked at the taxi driver defense. So a story is told. No, not a story. It actually happened. In 1981, a man named John Hinckley Jr., an American, attempted to assassinate US President Ronald Reagan. So he wounded Reagan. Reagan didn't die, but he went on to feel the extent of, the law process. But the backstory here was Hinckley became obsessed with a film called Taxi Driver. It was a film done in 1976. And in the movie, there's a disturbed protagonist named Bickle who plots to assassinate a presidential candidate. Now, Hinckley develops this infatuation with one of the actors in the movie called Jodie Foster, a lady. And she played a 12-year-old child in the film. Anyway, so failing to develop any kind of meaningful contact with the actress, Hinckley really fantasized a lot about how to, how should I do an airplane hijacking? Should I commit suicide in front of Jodie Foster to get her attention? And eventually he settled on this assassination scheme. So he tried initially with Jimmy Carter, and then he was arrested on gun charges. And then he tried to collect as much material as he could about the JFK assassination. And then on that day in March, he attempted to kill Ronald Reagan. So when they went to court to convict Hinckley for the assassination attempt, the prosecution had the job of proving that the defendant was either not mentally ill, or if he was, that he could still appreciate the wrongfulness of his actions and conform to the law. Now, the defense psychiatric reports portrayed Hinckley as insane, and the prosecution said, no, he is legally sane. So Hinckley eventually was found not guilty, I think in 1982, and this caused a lot of disarray. People were so upset with this decision, and you even have Hinckley saying after his trial that this was after the shooting, that this was the greatest love offering in the history of the world. And so people were like, people were disappointed that he got a not guilty verdict. Now, the public outcry led, because he was found not guilty by virtue of insanity, like he was not of sane mind. This led to the Insanity Defense Reform Act of 1984, and this altered the rule for consideration of mental illness of defendants in criminal courts and proceedings. So along with Hinckley, we have Lynette Fromm and Sarah Moore, who also are one of the 3 people who've attempted presidential assassinations, who are actually not in prison. They're living in sort of psychiatric wards and things like that. Hinckley himself was released in 2016 after leaving psychiatric care. So the interesting thing here is, and I think the thing I picked up is, how do you determine that somebody is actually insane? And you could be insane at the point of committing the crime and not so insane later on. And so it's very interesting because they say there's a huge group of people with mental illness that commit crimes, but they don't meet the test for insanity. So I find it really like crazy that you could have, the mens rea, the intention, you may not have intended in that moment, but you don't meet the threshold for insanity because you're not on the extreme levels, right? And the interesting thing about your mind is that unlike a broken bone that you can see and a doctor can see is broken, your brain and your mind is so much more difficult to discern what is broken or not, what is not working at that sanity level. And so they say, really, that you have to be capable of abstract thinking to be considered of sound mind. However, I feel like it's a little bit more complex than this. And I feel like trying defendants for cases that they don't understand, that they committed or had violated some kind of law, is really violating their constitutional rights. If you didn't understand it, should you be tried for it? Anyway, interesting stuff. I'm not a lawyer, but I had a lot of fun reading up on this. So I'll end with this. On a day where we had the winning headline from Standard and a winning cartoon from The Star, a quote by Louis Brandeis. Our government is the potent, the omnipresent teacher. For good or ill, it teaches the whole people by example. Crime, then, is contagious. If the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself, and this invites anarchy. To declare that in the administration of the criminal law, that the end justifies the means, to declare that the government may commit crimes in order to secure the conviction of a private criminal would bring terrible, terrible retributions. And so in the end, do we get the criminals we deserve as a nation? That is the question. Please have a lovely evening. Please subscribe to our YouTube channel, but find us on TV, on GoTV, Pang Peter, and Spotify.